My lord, one matter is there. Senior advocate, senior Shambhu Sarkar is admitting, my lord. But
Yes. Yes, Mr. Sharkar, the matter has.
Lordship, I haven't mentioned.
It because I was told this morning by my court officer, the records are in Calcutta.
Yes, my lord.
So
Yes, my lord. Possibly it is in Calcutta, Lordship. Lord,
Yes.
all I pray, my lord, that Lordship, can it direct that the records be brought to be sent to Port Blair, and let it be fixed Friday, my lord. I'll take my chance if it can be found in the meantime.
record
Transmitted to Port Blair.
কতদিন হ্যাঁ পোস্ট অফিসের উপর Mr. Sharkar, what we
Lordship, the next Friday.
yes,
Yes.
we'll make an effort. So অর্ডার দিতে হবে আমাকে না তুমি আনিয়ে নেবে নিজে আনিয়ে নেবে এটা নেক্সট ফ্রাইডে তাহলে রাখো তার ভিতর রেকর্ড এসে গেলে লিস্ট করে দেবে হ্যাঁ we'll do that, we'll record an order. This matter was directed to be listed today. Stop. It has not been listed because it has transpired that the records are lying in the principal bench at Calcutta. Paragraph. Let the records be transmitted to the circuit bench at Port Blair. Stop. List this matter once again on give Friday's date.
9th, madam.
Not once again, list this matter on because it is not there in today's list. List this matter on Friday.
And my lord,
I was told that you have landed in Port Blair. You'll be coming physically.
my lord, yes, my lord, I had my tickets, but since I found matter is not there, and I also checked up the file is in Calcutta in principal bench, my lord. So, my lord, Lordship, pardon me.
That could hardly be a ground for your cancelling the trip. The weather is beautiful here.
My lord, God willing, we'll meet on 9th, my lord.
Yes.
Well, there is a system appellate side that we say that records be brought by special messenger at my cost, or they have to deposit special messenger cost. That can also be done.
At the cost of the appellant. You're the appellant. No,
I'm not a petitioner. The writ petition. The writ petition.
হ্যাঁ স্পেশাল মেসেঞ্জার বুঝতে পারছো কি বলছি কুরিয়ার at the cost of the let the what have I said Port Blair through special messenger at the cost of the writ petitioner.
Department will intimate my admin record will get informed by today itself the cost.
Order be communicated to the concerned department in the principal bench at Calcutta in course of the day.
I'm deeply obliged, man. I'm deeply obliged.
Next, call the list. Yes, no, this, you see, these are fairly old matters, so I have searched them out and listed them. So not today is fine, but oh, then let there be direction. Check. Very well. This is right, Stephen. This is an old matter of 2020. Stop. It has been listed at my instance. Paragraph. Learned advocate for the respondents seeks a day's accommodation to look into the matter. Paragraph. List this matter once again on give Monday's date.
Item number 2.
Very well. Learned advocate for the appellant says that the respondent has passed away during the pendency of the second appeal. Paragraph. Let this matter stand adjourned and be listed before the next available circuit bench. So in the meantime, the appellant shall take necessary steps in the matter.
Item number 3, in this case, my lord, there is a order of 121. Same, my lord.
Stay of the order of the stay of what?
Here the very, I just explain my lord. Consumption order to itself being there is a status of order
By the authority reviewing the land of the citizen. That was challenged with this particular case. The petition was allowed and the challenge came by then the division and also was answered. They went to the Supreme Court on this state that in the meantime what happened, the election was delayed with regard to that society. So one application was filed before the Honorable Court for a direction upon the registrar of cooperative election. That petition was allowed to my favor. Thereafter, I filed, because they were not holding the election, I filed a contempt application. That contempt application was not be proceeded with because of the stay order granted by the Honorable.
And that is still the situation. In view of the fact that the proceedings are still pending before the Honorable Supreme Court and the stay order is continuing, let this contempt application go out of the list for the time being with liberty to mention.
In fact, my lord, this is explained 8 December 2021 order explains the situation.
Yes, yes.
Item number 4, CPM 7 of 121. No, there is no, because the matter is pending before the Supreme Court.
Though there is no stay, but matter is pending before the
Since the matter is pending before the Honorable Supreme Court, let this matter go out of the list with liberty to mention.
Item number 5, here 13 of 121.
I'm appearing for the respondent, my lord.
Pass over.
Obliged.
Item number 6, WPA 58 of 121.
Right from 6 to 11. These bunches of matters involve same.
Yeah.
Out of 8 lordship, 10 has been disposed of. I can raise those orders before the school. And even these matters can be disposed of in the same line.
Same line.
Same.
Yes, what do you say?
I don't have the file, my lord.
You can supply a copy of the order. Make this just not today. 6 to 11, not today.
Item number 12,
Well,
WPA 19 of 121.
a situation where the government has encroached on private land of a person. Now, this writ was not proceeding in an adversarial manner because with the pendency of this application, the government also realized there are 2 adjoining plots. They are on mine. Now, what has happened is there's a process of shifting. This encroachment is to make a school, which has been there for a long time. So we also were not really putting to that extent. The government also, because of the pendency of this writ, has been moving out the school. So the matter had been directed to go out of list. In the meantime, I think the construction is going on the other plot. Some of the classes have been shifted. It's an ongoing process.
Very well.
So, my lord, that's why the court was of the opinion also let it go out of this with liberty to mention. Once this is done, we will mention. Because if today we say infractions or anything, then that process will also perhaps be eliminated. So there's nothing really contentious here. Just
It appears that the dispute with which the writ petitioner approached this court, may stand resolved over passage of time. Paragraph, let this matter go out of list for the time being, comma, with liberty to mention.
I'm appearing for the
same
response.
Position is probably recorded already in the previous order.
Oh. Anyway,
Appearance. Highly
Item
obliged.
number 13, WPA 254 of 2021.
Your Worship, I am for the petitioner.
yes,
Your Worship, this case was not proceeded because similar matter was pending before the Honorable Division Bench. Now that the matter has been disposed of, so this matter can be taken up for hearing.
very well. When? Monday?
Monday, I will inform separately.
Division means what, from interim order or what?
Similar.
Similar issue. Bring that order.
Yes, yes, I will bring that.
On those lines, we'll dispose of. Learned advocate for the petitioners says that this matter was not proceeded with in view of pendency of a similar issue before a division bench. Stop. The division bench proceedings have concluded. Paragraph. List this matter once again on Monday's date. Give when a copy of the order of the Honorable Division Bench should be made available to the court.
Item number 14, WPA 270 of 2021.
Lordship, in item number 14, 15 and 16, I am seeking for a short passover.
14, 15, 16, very well. 14 Passover, 15 and 16 not today.
Passover, my lord.
Which one?
15 and 16 also.
You are for whom, Mr. Prashant?
I'm for the 15, I am for the petitioner. And read to
15 petitioner says not today, why should we pass it over?
I have instruction to take passover. in
Where
this
you have
matter.
instructions,
I can ask from
then pass over.
Passover when we will come.
When-
That we don't know.
That is the reason, my lord, we fixed on Monday.
It's fine with me, not today then. 15 and 16 both.
Yesterday also they have taken an adjournment.
Today you are praying for time, madam.
I'm seeking for passover, my lord.
No, not today. Next.
Item number 17.
Lordship, item number 17, I am for the petitioner lordship. First, I prayed for an interim order. Sir, this is the.
Already they have taken out an appeal, which is pending before the district judge against an
No.
order under Order 9, Rule 13.
That is
Because the
different.
decree merged with the order. They have challenged because under Order 43, order passed under Order 9, Rule 13 is appealable. They have already laid an appeal. So they have not pressing the appeal there. Now they want an order of stay of eviction decree from this court by the present proceeding.
No, no.
1998 eviction suit was filed, Lordship. I could get it 2011. Then they have come up before the trial court under Order 9, Rule 13. Evidence were led. The trial court was satisfied with.
It was ex parte decree.
No, my lord.
Ex
But
parte
it was contested.
No, no.
The decree records ex parte, but original records, if my lord sees, they all through participated. My witnesses were cross-examined, but while drawing up the decree, it's a minor slipshod, my lordship. The trial court mentioned order ex parte. Taking undue advantage of the situation, they have not preferred an appeal. They approached the same court under Order 9, Rule 13. Even under Order 9, Rule 13, evidence were led to show whether there was sufficient cause.
And that was decided ex parte.
No, that on.
And it is that order I
They
prefer
appeared.
appeal.
They argued, some other lawyer was there, Mr. My Adjournment was
lordship,
not there.
Here,
I know, I was.
Order
in
is under
section, I know
challenge.
everything.
So Order 9, Rule 13 was rejected.
Yes, no contest.
And they have preferred an appeal
Appeal.
against that.
appeal lordship. Recently, I preferred appeal. Recently, I preferred appeal lordship. But I entered, the council entered only on 23rd of July lordship. So this is my application lordship. Kindly allow 1 minute, I will apprise this lordship.
This revisional application is directed against which order?
Order dated 23 lordship. That is very interesting. On 23rd, before the executing court lordship, the matter was set down for filing report by the bailiff for giving possession. But the bailiff filed a report on 23rd that is contradictory lordship. On the one hand, he is stating that he had been to the shoot property. He found the door is locked. He could not serve directly. Rather, he affixed a
Show me the order which you have impugned here.
lordship, factual, 2 minute lordship, then I am coming lordship. Then lordship, he could not serve. Rather, he affixed a notice on the outer of the shoot property. Lordship, on the other hand, the possessed server is stating, lordship, very interesting. He requested the judgment debtor to vacate the shoot property in terms of the warrant to bailiff. He could not serve lordship. He affixed outer door. On the other hand, he is stating that the decree holder is resisting. He is making obstruction. There is disturbing public peace, tranquility, and nuisance. All these. Lordship, on the same day, a police self petition filed by them without giving an opportunity of hearing, that petition is allowed in view of the commission Nazir report. I am coming, Lordship. Kindly have a look. First, page 18, Lordship.
No, why? Why should we enter all these things? Disputes? What, this is an appeal court or what?
No, Lordship, Lordship, I am here only to show the illegality and material
What illegality? You have
that
suffered
committed,
an eviction decree.
Lordship knows that legality, illegality emanates from the facts, Lordship. Kindly allow me, Lordship, I will take just 2 minutes. I will not take much time, Lordship. Kindly have a look, Lordship. The report I am reading.
During the last visit.
Please, it is
Just
my
1 second.
application.
Had an
Lordship.
obligation to deal with the second appeal of eviction decree. My lord has saddled my client with cost because my client was resisting the execution case. I will place that order.
Lordship,
Same thing, same, my lord has passed the
on
order.
the
Cost was imposed.
face of the record, it is contradictory and it is illegal, Lordship.
Show me.
Lordship. Page 18, Lordship. This is the report filed by the Nazir, Lordship. I am reading, Lordship. We, Krishna Majumdar and Gopal Chandra Das, Lordship. Got it, Lordship?
You have come up against the Nazir's report.
No. Nazir's report.
I want to see
followed
the
by
order.
Lordship.
Page 15.
Lordship. Start from page 14, Lordship. Page 14. This is the first order. Lordship, I am reading.
No, please don't read. Allow me to read.
Lordship. Learned advocate for the.
Allow me to read.
Lordship.
You have not preferred an appeal against the eviction decree.
Lordship preferred.
Appeal.
No. Order 9, Rule 13 was filed.
Simple question. Have you preferred an appeal against the eviction decree?
No appeal is preferred. Rather, Order 9, Rule 13 was preferred. Lordship knows that I have two options.
Yes, I've read the order.
Lordship, next order, Lordship, page.
The orders I've read.
Now, Lordship, once at a glance, Lordship, the report of the Nazir, Lordship. He is stating that he could not serve, door was locked. That is page 18, Lordship. I am reading, Lordship. We, Krishna Majumdar and Gopal Chandra Das, process server, the bailiff of this court, that 1/19/7/2024, we received this warrant to the bailiff to give possession of land, etc., to the decree holder, Calcutta Trust Association, from the judgment debtor Sri Alok De and others. Lordship, 1/22/7/2024 at about 11 p.m. AM, we went to the spot. The shoot property has been identified by the attorney holder of A. Justin, but we found one house door was locked. Once reply the warrant, we affixed on the front wall of the shoot property in the presence of power of attorney holder of the A. Justin. we asked the judgment debtors to vacate the suit property. Then, Lordship, we asked the judgment debtor to vacate the suit property or in the as mentioned in the warrant, but they refused to vacate the suit property. Again, we further tried to vacate the suit property, but judgment debtors and his family members raised obstruction, and thereby there is a breach of peace and public tranquility, so we could not serve. But on the one hand, he could not meet with the decree holder. Other hand, he is saying that there is Lordship. Then the very interesting things that next petition for police help was filed in the month of April, and report filed by the Nazir is 23rd July. And the contention of the report is similar to the petition filed in the month of July that has been allowed without giving an opportunity of hearing on 23rd. This is my grievance, Lordship. This is the illegality. I am before your Lordship.
Excellent. What was it, the prayer in your application that you filed before the executing court that was rejected by the impugned orders?
I challenge, Lordship, the report filed by the Nazir.
Nazir's report you challenged
Nazir report
and for setting aside of
for
that
setting
report.
aside the Nazir report.
Come. When was the suit filed?
1998,
98.
1998,
And suit was decreed in
2011.
No,
2011.
2017.
2000?
Okay, so I'll go with 2017. My record is
17.
my lord.
Then
Execution case in 2018.
My
13. Then what?
After you started execution, he applied under Order 9, Rule 30.
Rule 13.
And on that count, execution.
That has been decided, Lordship,
Just 1 second.
1/4
In abeyance.
5th April of this year.
Very well. Allow me, allow me. By filing this revisional application, comma, the judgment debtor in TS number,
I'll just give you just 1 second.
TS number blank
I'm giving you.
of 1998, comma, challenges judgment debtors, not one, huh? Challenge order number 58 dated July 23, 2024, comma, passed by the learned executing court in other execution number 01 of 2018, paragraph. An eviction suit was filed by the opposite party herein against the present petitioners in the year 1998. Stop. The suit was decreed after passage of 19 years in 2017. Stop. The plaintiff oblique decree holder initiated execution proceedings. Stop. Thereafter, the judgment debtors applied under Order 9, Rule 13 of the Code of Civil Procedure for recalling of the decree on the ground that it was passed ex parte. Stop. Paragraph. Learned advocate for the opposite party herein says that it was not an ex parte decree. Stop. That word ex parte within quotes here, was erroneously used in the decree. Stop. Paragraph. Be that as it may, comma, the application under Ordinary Rule 13 of the CPC was dismissed by the learned trial court. Stop. I am told that the petitioners herein have preferred an appeal against such order of dismissal, which is pending before
Learned District Judge.
the learned district judge,
Miss Appeal number 16 of 2024.
Port Blair, being Miss Appeal number
16 of 2024.
16 of 2024. Paragraph. In the execution proceedings, comma, the Nazir filed a report on July 22, 2024. Stop. The report was to the effect that the door of the suit premises was found locked. Stop. And thereafter, the process server was registered by the judgment debtors. Stop. A notice was fixed on the front wall of the suit property in presence of witnesses. Stop. Paragraph. The judgment debtors made an application before the learned executing court for rejection of the aforesaid report of the Nazir, saying that the same was riddled with inherent inconsistencies and was a false report. Stop. By the order sought to be impugned in this application, the learned executing court rejected such application of the judgment debtors. Stop. By the said order, the learned executing court also allowed, cancel also, executive court allowed an application of the decree holder for police help for execution of the decree. Stop. Paragraph. I have gone through the order dated July 23, 2024, sought to be impugned by way of this application under Article 227 of the Constitution of India. Stop. I find no apparent infirmity in the said order, nor any illegality or procedural impropriety. Stop. While exercising power under Article 227, the High Court does not act as an appellate court. Stop. Its role is strictly supervisory. Stop. Such jurisdiction is to be exercised to correct excess of jurisdiction or patent illegality leading to manifest injustice. Stop. I do not find any ground to exercise power under Article 227 of the Constitution of India. Stop. On the contrary, it appears that the present application has been filed only for the purpose of stalling the execution proceedings. Stop. Stalling the proceedings for execution of a decree which the plaintiff could obtain after 19 years of litigation. Stop. Paragraph. The application is completely meritless and frivolous. Stop. The application is dismissed with costs assessed at rupees 10,000 to be paid by the petitioners to the opposite party.
Lordship, cost may.
Title
may
suit
not
number
be-
2 of 1998. Lordship.
Hey, that
Old-
suit is
of
1990.
1990.
Blank I had said. na?
Lordship,
2 of 90.
1990.
Lordship,
I'm grateful.
cost may not be.
This is a mala fide application, sir.
Lordship, Lordship, one ground, kindly allow me, I want to, last one ground, Lordship.
After dictating the judgment.
No, Lordship.
Sorry.
Kindly appreciate, one,
Come.
Lordship.
Come.
For-
Not after dictating the judgment, sir. You are fairly senior counsel. Don't do this.
No, Lordship, here the application for police help filed in the month of April, Lordship. And.
Call the next matter.
Item number 18,
I'm grateful.
WPA 348 of 2024.
My lord, in this matter, I am appearing for the writ petitioner, my lord. On the
Yes.
last date, I had stated that I will be filing the citation to that extent.
Citation.
Yes, my lord.
But my details is appearing for official responded, Your Lordship. I
Yes.
pray for not today, Your Lordship.
Not today. Not today. What citation, sir?
My lord, the matter was that whether the Tahsildar can mutate the property on the basis of a will which has not been tested by a civil court.
Oh,
was that contention and the
you
citation.
keep this, she's asking for a day's accommodation.
My lord.
Not today.
Item number 19.
My lord, this is that matter, my lord, where my lord had indicated that I should seek instructions, my lord, regarding that claim of the contractor. My lord, I've sought instructions, my lord. This claim arises on account of a construction of a wall which was constructed without authority, without seeking
Construction of
prior-
what? Construction of what? Wall.
Wall.
Diwal.
Yes, my lord. But this was without any prior approval or sanction. So, my lords, I need to file an affidavit, my lord. My lord,
Whether
may
how
evolve
they can
eventually,
say,
that's
they
a
have
different
undertook
thing.
the work, they publish the
No,
open, my lord.
No, my lord,
the
this
law-
is a dispute, my lord. There are arbitrations, my lord, which are fought on issues like this.
Let them file an affidavit.
Let them file, it should not be, so. My lord knows very well.
My lord,
For
may
purpose
hold
of
that
tender,
eventually.
without sanction, they have issued a tender, they executed the work, they made the payment, only 9 lakh rupees, 15 lakh rupees.
9 lakh is on
You fix
account of extra.
responsibility upon the officers, without
9 lakh
approval, they have carried
is
it.
on account of extra work which was not
My
approved.
lord, how they can say this, my lord, this type of
This can't
submissions.
be heard by this circuit.
Yes.
If they're filing an affidavit, when it comes up for hearing,
My lord,
I just hope there's a very strong judge who gives it to your client.
This sort of submission.
Learned advocate for the Port Blair Municipal Council says that his client would like to file an affidavit in opposition. Stop. Let such affidavit be filed within 3 weeks. Yes, 3 weeks,
Sir, my lord, more time, my lord. 4 weeks. 4 weeks may be granted.
4 weeks from date.
Very kharab.
Stop. Reply thereto, comma, if any be filed within
a
week thereafter. Paragraph lists the matter after 5 weeks before the then available circuit
My
bench.
lord, most great.
Mm.
Item number 20. WPA 365 of 2024.
Well,
for the
these
petition
matters, the copies has been served on me today in the courtroom. I will be allowed to take instruction.
These are similar matters.
Similar
Yes.
matter, my lord.
What? Fresh connection?
Fresh connection, my lord. I have applied, but
Fresh
they have
connection.
no
My
response.
lord, I have to take instruction
My
from
lord-
the department, whether
my
it
lord,
has been
already- my
given
lord-
already or not. This matter relates to Austin Creek. They are
My
immediately.
lord, already the same village order has been
My
passed
lord-
in the previous circuit.
My lord, I have to
And
take
my lord has
instruction. He has
pointed out-
given during the course of
Very
the
well.
day.
Come back on
My
Monday.
lord, my lord, my lord.
All these matters, record an order in all these matters. Learned advocate for the respondents seeks a day's accommodation
Well.
to obtain instructions.
Well.
Paragraph lists this matter once again on give Monday's date.
Indeed.
Same order in 20 to 25.
Right.
Item. Item number 26. WPA 1030 of 2023.
Your lordship, my senior Miss Anjali Nag is appearing on behalf of the petitioner, your lordship. I pray that this matter be fixed on this coming Monday, your lordship, 5th of August.
Yes, Mr. Chakraborty.
No different. This is the matter which your lordship heard at length yesterday, that the registration,
Registration of adoption. deed.
correction, adoption deed.
Oh, very well. On the prayer made on behalf of the petitioners, comma, let this matter stand adjourned for the day.
Item number 27. WPA 1090.
My lords, I have an objection, my lord, to the maintainability of this writ petition. This is a purely commercial dispute, my lord. Arbitration clause is also there in GCC.
no arbitration clause in
There in the GCC, my lord, there is arbitration clause also. And
General
I've got-
conditions of contract?
My lord,
General conditions.
I have drawn, my lord,
And
page 33 of this writ petition. Kindly come once. My lord has heard this matter.
yes, my lord, my lord had asked us to seek instructions on page
Page
30.
33.
I recall, my apologies. क्या बोलना है?
तीन साल में करना होता है। He has made it after.
नहीं, वो तो बोल रहे देने के।
हाँ, तो he has ignored that.
Yes, that internal note was
Yes, my lord,
placed.
but my lord, that is my lord, yes, my lord, I apologize.
My lord, there is an admission
First.
towards payment.
My lord, this is an internal note, my lord, and my lord, we do not, this is not the decision of the authority, my lord.
And
The executive engineer has given
I
this,
just want to draw another
but
document.
the,
Page 26.
but the employer doesn't agree with this
The principal doesn't agree with this internal view of an officer, my lord. It is not binding, my lord.
But that is not there in their affidavit.
No, the
Affidavit
decision
is
is-
right.
They did not deny this document.
No, nobody, I'm not denying the existence of this document. I am saying that this is not the decision which has been taken. We are not bound by some
How
internal.
have you dealt with this document?
Point out. Para 12 it is mentioned, and my lord may have an opposition in response to paragraph 12.
P6 is referred to in which paragraph?
Para 12.
Para 12. And their page 11 of their affidavit in opposition, para 14.
Yes, what is your ground for not releasing the payment, security deposits?
The want of completion certificate and test check report.
Who is to issue that?
That is the
Completion certificate?
executive engineer.
They will, but this is required. It was not issued. So if it was not issued, then my lord, then it is deemed that it is
To
not.
be issued by whom?
Executive engineer.
Executive
The
engineer.
this, the
Which
same person.
employee is the executive engineer?
No, but he has to, if he's satisfied, then he'll issue. So if he hasn't issued, means he's not
It will be
satisfied.
personally present in court.
The same
This
person.
attitude of your client is not appreciated, Mr. Chakraborty.
My lord, I'll take
Not,
it, sir.
not appreciated.
My lord,
I'll call your chairman if necessary.
My lord, I'll take his.
Monday.
Only
Monday.
instructions, my lord.
What is this?
I appreciate.
The same person whose note is there.
I normally am very, very lenient and liberal. If I want to be tough, I can be very tough. You tell your client.
No, my lord may then dispose of my lord based on this note, my lord.
Yes.
That can
You
be.
go up on appeal, you get it stayed by the division bench. But what is this? I don't want to make, if I dictate a judgment full-fledged, I'll have to make very strong remarks. So if you want, you can take instruction. After all, it's an Article 12 authority, Mr. Chakraborty. One must act reasonably, fairly. You show me, yes, the quality of work is not good, material used is not good. Surely, I will not pass an order. But just for the sake of withholding the money, raising a dispute, these are small parties. These are all directed against your client, naturally, not against you. You know
My
that.
lord, I appreciate. The CPWD manual as a requirement, my lord, that is the only thing, my lord. Otherwise, my
That's
lord.
beyond his control. Your internal record shows that the work was satisfactorily done. Now, if the executive engineer does not issue certificate, what can he do?
My lord can then direct my lord, mandamus may be issued.
Very well. Come.
My lord, no concession may be required.
No concession. Similar matters, all similar matters,
All
different
similar.
work orders.
All similar to us. Same issue.
So one order I'll pass, combined order. All these writ petitions, this is numbers,
10902.
no, 27 to, item numbers 27 to 32.
My lord, that GCC is only for the purpose of record, my lord.
Acha, arbitration.
Clause 25.
This is not there in the,
No,
this is a work order.
No, it is the contract is under.
No, no, it is not there. My lord,
How can you say that?
every contract.
It is built in every contract and tender issued.
It
my
is
lord.
the work order. Please do not.
If there is a dispute,
My
it is,
lord. No, that my lord.
all these writ petitions involve the same question, issue of fact and law. Stop. Therefore, comma, these writ petitions have been taken up together for hearing. Paragraph. The writ petitioner is a society which has been formed by unemployed persons. Stop. What kind of work? Civil construction.
Civil construction, retaining wall,
Stop.
sea wall. The name of work is there, man.
Where?
I'll just show. Kindly come see.
Yes, construction of CC drain. In Neil Island,
Neil Island.
all the work orders.
All the works are Neil Island. Different phase. Phase 1, 2, phase 6.
The society carries on business of civil construction. Stop. Paragraph. Several work orders for construction of CC drain in different phases in Neil Island were issued in favor of the petitioner society. So the petitioner says that it completed the entire work to the satisfaction of the who issued the work order?
Executive engineer, PRI.
PRI.
Kindly come to page 32.
32.
You will get all the work order phase and
To the satisfaction of the panchayat in question. Stop. The bills of the petitioner society have also been paid, excepting for
withholding 10% towards security deposit.
10%
10% towards security deposit
of towards security deposit and test check,
and 10% towards test check.
and 10% towards test check
Total 20%.
by the executive engineer. Stop. Hence, the petitioner has approached this court by way of the aforesaid writ petitions. Stop. Paragraph. Learned advocate for the respondents says that the aforesaid says that the withholding of 20% of the bill amount is an account of the fact, is by reason of the fact that the test check has not yet been carried out and
Completion certificate in terms of CPWD manual.
completion certificate in terms of the CPWD manual has not been issued by the executive engineer. Stop. Sir, what will be more appropriate is I will direct the executive engineer to do the needful within a time period. That will be more appropriate than passing a money decree in a writ petition. Stop. Paragraph. Learned advocate for the petitioner has drawn my attention to
Page 33.
33,
Page 33.
an internal note of the
The issue of delays also then.
when was the work order was off?
No, the delays 12 years.
Delay in approaching court.
Delay in approaching court or getting the completion certificate, whichever way it is seen. 12 years. The note also records that. This is actually, it has to be obtained within 3 years. The completion certificate and test check report is to be obtained within 3 years. And 12 years have passed, but the authority says that this relaxation should be given to them.
Yes. Has drawn my attention to an internal note generated by the office of the executive engineer. Stop, comma, which reads as follows. Page 33, set out the entire note, 33. Paragraph. It appears from the aforesaid note that the work was satisfactorily completed by the petitioner. Stop. The learned advocate for the respondents could not point out any complaint from any quarters regarding the quality of the work done by the petitioner. Stop. Paragraph. I am conscious that normally the writ court would not pass an order which would amount to a money decree. Stop. However, if there is no dispute regarding the claim of a contractor, then the writ court would be justified in intervening. Stop. Paragraph. In the present case, I do not find any legitimate reason for the respondent authorities to withhold the claim of the petitioner society. Stop. It is not the responsibility of the petitioner society to conduct test check, nor can the petitioner society issue completion certificate. Stop. It is up to the executive engineer, concerned executive engineer, concerned to do so. Stop. Have you made the executive engineer party?
Yes. Yes, my lord.
Number?
I'm just telling. Executive engineer is 3, respond number 3,
Yes.
page 9.
Yes. Stop. The petitioner society cannot be made to suffer for inaction or indolence on the part of the concerned executive engineer. Stop. Paragraph. Accordingly, I direct the concerned executive engineer, being the respondent number 3 herein, to undertake the test check immediately and in any event within
Record the completion certificate also.
4 weeks from date, and then to issue the completion certificate if everything is found to be in order. Stop. Upon in order. Stop. Such completion certificate will be issued within 2 weeks from the 2 weeks after test check is conducted. Stop. The amount due to the petitioner society will be disbursed by the respondent authorities within 4 weeks from the issuance of completion certificate by the concerned executive engineer. Paragraph. In the event the executive engineer fails or refuses to issue completion certificate, it shall communicate the reason therefore to the petitioner society in writing. Stop. That is all, Mr. Chakraborty, Mr. Das.
Right.
Paragraph. The writ petitions are disposed of accordingly.
Obliged.
Oh, actually, just add one, make one rider, I'll add it, I'll insert it. Mr. Chakraborty, our learned advocate for the respondents, said that this writ petition should not be, these writ petitions should not be entertained since the general conditions of contract, which form part of the work order, correct?
Let me just say that when the disputed questions are involved.
Since disputed questions are involved and there is an arbitration clause in the general conditions of
It is not
don't
there,
want to
man.
know.
It is not there, man.
Oh, since there are the disputed questions of fact involved, stop. I do not see any disputed question of fact in the present case, stop. The internal note of the Office of the Executive Engineer
Address to PR, super engineer.
addressed to the superintending engineer leaves no scope for any dispute. Just make it rider A, I will indicate way to.
Obliged.
Must have been there in the tender, but it was not on record, so I don't know.
Item number 33, WPL 643 of.
I am for the.
My lord, in this matter, I am for the private respondent.
And for official respondent. By this honorable court on 21st June. That may be seen, my lord, I need not to submit anything.
Now,
21st June.
Joseph. PBMC,
My lord,
Not a single notice was issued.
you are the
I am
PBMC.
appearing for PBMC. My
The appeal has been disposed of.
lord. The appeal is before the appellate authority and deputy commissioner, my lord. They are not the party and the appellant will be in better position to.
You are not a party.
Appellant authority is not a party. PBMC is a party. PBMC has passed an order. Against that order, the appellant has challenged.
PBMC must be a party in that appeal.
yes, my lord.
Yes.
My lord.
They have been served, my lord, in my affidavit in
You are the
opposition.
private respondent.
I am for the private respondent
What
and I have
is the
served.
Order I communicated.
My lord,
Prashant.
my lord, I am for the private respond, my lord, and my client is continuously approaching the deputy commissioner and the deputy commissioner officer stated that they will be issuing the notice this week. We are prepared for the hearing
The
of
appeal
the
has not been heard.
No, my lord.
appeal has not been heard. And we are ready
Period is already
for
over.
the appeal. And we are ready for hearing of the appeal, my lord. But
Yes,
only
we
one
want
question
to
is
accept
that,
the High Court's
no,
order.
my lord, we are ready, but only one question regarding the writ petitioner against whom the implementation order is being sought is also passed against the said writ petitioner.
Have not followed.
The writ petitioner is not my adjacent tenant. The demolition order has been passed with a subject land, and the subject land owners are both writ petitioner and the private respondent.
Yes, but impugn construction has been made by whom?
Private respondent.
The notice has been issued upon all of the writ petitioner and private respondent. We all, and I was having the valid building plan.
Brothers and sisters, my lord, without giving any share to me, he started construction.
My lord, let
That is
me
the reason I
demonstrate
approached
my
the
case,
authority.
my lord. I had filed my affidavit in opposition. I can demonstrate, and both the parties.
You don't have to demonstrate anything. let
Yes.
the appeal be disposed of.
Yes,
Uh,
Only one
no,
subject.
I'm calling for a report from the appellate authority.
I communicated this order of 21st June on 26/6/24.
I'm calling for a report. Why the order, read order dated June
21st.
21, 2024. Paragraph. By the aforesaid order, the appellate authority being the
Deputy Commissioner South Andaman.
Deputy Commissioner, South Andaman,
Yes.
was directed to dispose of the appeal, statutory appeal,
Yes.
statutory appeal
Filed by the private respondent.
filed by the private respondent, one or many private respondent,
One only.
One.
private respondent in this writ petition, assailing a demolition order issued by the
Municipal Council.
Port Blair Municipal Corporation.
Council.
Council. Stop. Stop, comma. Within
4 weeks.
4 weeks from the date of that order. Paragraph. Today, I am told that the appeal is still pending.
I communicated to the Deputy Commissioner.
Learned advocate for the writ petitioner places a document on record. Places a letter dated June 26, 2024, on record, communicating this court's order dated June 21, 2024, to the Deputy Commissioner, South Andaman. Stop. Paragraph. Let the Deputy Commissioner, South Andaman. I direct the Deputy Commissioner, South Andaman, to file an affidavit before me on the next date, explaining as to why the order, this court's order dated June 21, 2024, has not been complied with. Stop. This matter once again keep it on next Friday.
Thanks.
Stop. If in the meantime the appeal is disposed of by the Deputy Commissioner, a compliance report will be filed on the next date.
That will be done, I believe.
That is exactly why I recorded. We also know how to get things done.
Not plain copy, sir.
Plain copy.
Website copy.
Website copy you'll get today.
Yes, sir. Yes, I'll communicate.
This is.
Highly obliged.
Obliged.
My lord, registry may be directed to send a copy to Deputy Commissioner.
Yes, that's also. Our registry is directed to send a copy of this order immediately to the Deputy Commissioner, South Andaman.
Obliged.
Highly obliged.
Item number 35. Item number 35. WP 915 of 2023. Item number 36.
Your lordship, I want till Monday, your lordship. My reply is ready.
Not today.
Monday, sure. I'm sure. थोड़ा सा बचा हुआ है.
Let it then come on Tuesday.
Let it be on Monday, my lord, because my matter is ready since long and I want to do the matter.
No, the reply, I have to go through the reply. Let it be Tuesday.
Well, let it
कुछ खास नहीं है.
apply in advance.
Yes, I will give you an
Advance copy. If she
I'll
can
give you an
give.
advance copy.
Item number 37. WP 137 of 2020.
Lordship, I am for the petitioner, Lordship.
Respondent 2, 3 and 4, my lord. I have already filed my opposition note before the registry.
I have not received. Lordship, I will be filing my reply, Lordship.
When?
1 week, Lordship.
1 week.
Yes, Lordship.
The respondent numbers 2, 3, and 4 have already filed their affidavit in opposition. Stop. A copy of such affidavit is made over to learned advocate for the petitioner in court today. Paragraph, the petitioner will be at liberty to file affidavit in reply within a week from date. Paragraph lists the matter before the next available circuit bench.
Yes, Lordship. Grateful, Lordship.
Item number 38.
Here, my lord, I have to be fair to the other side, my lord, I have also examined the provisions. My lords, regulation 141 kindly have of the this land reform, land revenue and land reform regulation.
What is the issue? I have no idea.
This is an issue of whether whether a licensee, whether it is heritable, a license under the regulations is heritable or not. My
I
lord
see.
had posed this query on the last occasion. Now kindly, my lord may have regulation 141. 141, my lord may have 141. My lord will find defines the class of tenants. It says there shall be following classes. My lord has that page 25 of the
Licensee is also a tenant.
licensee is also there, and after that, my lord will see 148. It says, subject to the personal law, the interest of a tenant in his holding may pass by inheritance, survivorship, or bequest. Of course, my lord, there is a issue that whether they have produced a succession certificate, that those issues are there.
Yes.
On what basis? They have to then produce something. If there's a will, they'll have to.
What are they asking for in this?
My lord, in
petition?
this,
Substitution.
I have annexed the will. On the basis of will only, this application has been filed, my lord. I have annexed the will,
This is a
because-
substitution application.
my lord. As per the
Let me
will,
substitute and then.
Yes, yes. My concession may not be required.
No, no, no. Mr. Chakraborty, I used to appear for a lot of public sector
My lord.
companies, so I know exactly how it is.
in the substitution application, I have annexed the will. ma'am.
Where is the substitution application?
It's scan number 1 of 2022, my lord.
Can one?
1 of 2022.
Letters of administration will be required, but. Be that as it may. my lord.
The writ petitioner passed away on September 16, 2022, during the pendency of this writ petition. Stop. The present application has been made by one
Para
Shri
5.
Benedict Bernard Shah, paragraph 5 of the substitution application. For being substituted in the place and stead of the writ petitioner. Stop. This the present applicant has done on the strength of a will, block capitals, will, which he says is the last will and testament executed by the writ petitioner, since deceased. Stop. Paragraph. And what is the claim in the main writ petition?
My lord, when they are saying, my claim is, my lord, when the father got the land license, my land has been cancelled. My license has been cancelled. That I have come to know in the year 2017. In the written, in the affidavit in opposition, they are saying in the year 2002, they have cancelled, but I have not received any order from the authority by saying that my license has been cancelled. In the year 2015, property was mortgaged. Prior to that, the property, some part of the property was converted to commercial purpose in the year 2015. When I went in the year 2017 to pay my land revenue, from the concerned authority, they have said it has been cancelled. My license has been cancelled.
Paragraph, I find from the will, comma, a copy whereof has been annexed to this application, comma, that
Para
the
2, my lord.
present applicant is a beneficiary
Beneficiary.
named in the will. Paragraph, accordingly, I allow this application. Stop. Let the name of the original writ petitioner be deleted and the name of, don't say deleted, struck off, and the name of the present applicant be brought on record as the writ petitioner. Stop. Let the department, what is the procedure? The department will carry out the amendment or the learned advocate on record.
My lord permits, my lord, I will.
That is done here.
My lord.
Learned advocate on record for the applicant is granted liberty to effect necessary amendment in the cause title of the writ petition
Fine.
and connected papers.
Oblige me.
Paragraph can is disposed of.
Oblige.
Probate is, my lord, not required here. My lord. Probate
So
is.
I understand that may create a lot of problems, but then,
My lord.
huh? Acha, when should the writ petition be listed?
Next available, sir.
Huh?
Next available circuit.
No, I don't know difficulty. Substitution will take how much time they'll require, that depends on.
Substitution, you will just
Substitution, I will do it today itself. That correction
let
I
the
will
writ
do it.
petition be listed. Thursday, let it come on Thursday, we'll see.
Yes, it's not.
Well,
Give Thursday's date.
oblige me.
Item number 39. Here is SB3 of 2022.
Let it be Tuesday.
Item number 44, which is item 40, WPS 77 of 2022.
Also, I pay for respondent authorities.
Pass over.
Item number 41, WPA 173 of 2022.
We are ready, my lord, after lunch. We are ready, my lord, after lunch or.
Very well, I can come back. I can come back in half an hour
My lord,
and then, but I will rise a little early today
my lord.
for personal reasons.
Okay.
Early meaning, if we start at 2:15, I'll rise at 3 o'clock.
My lord.
My lord.
Will that be of any use?
As your lordship,
No,
if your
some-
lordship wants to rise
Monday, my lord.
earlier, it can be done Monday. There is no.
Monday, my lord, no issue.
Progress can be made. Some progress can be made.
Whatever comes to my lord, we are
Whatever
ready.
comments to your lordship.
I can happily come back in half an hour.
My lord, we are ready. Yes, my lord.
Now, whatever you say.
We are ready, my lord. We will.
You know, even now we can do it because I have a preliminary objection to maintainability. If my lord wants to hear now and get done with it, then.
Pangs of hunger.
Next
Half an hour.
So if he is continuing with the next 10 matters hearing, the rest of us are safe.
Yes.
Your matters are already released.
Yes.
You can go.
2 o'clock.
2:15.
2:15, yes.
My lords, I have a preliminary submission, my lord. This writ petition, my lord, is not.
This is number.
41. My lord,
Number 41, 173 of.
relief of reinstatement, my lord, is being sought by means of a writ petition, my lord. This is completely in the face of the full bench's judgment, my lord, of the Calcutta, Honorable Calcutta High Court.
Place this. My lord, maintainability has to be seen on the facts of the case. What happened in this case? This is the second round of litigation. Maintainability ought to be challenged at the threshold. Second, my lord, what happened? Here a statutory settlement was arrived between the parties. Statutory settlement under section 12 subclause 3, which is binding upon the party under section 18 of the Industrial Dispute Act. They have not adhered to this statutory settlement. We approached this court. This court passed an order to consider and pass an order. They passed an order. We have challenged that order in this writ petition. This is the second round of litigation. From 1971, Supreme Court judgment is there. If you are challenging the maintainability point, you have to challenge it at the threshold. Second round of litigation, you are challenging at no point of time when the writ was admitted. My lord may see none of the order they have challenged it.
It's an issue of, kindly see the wordings of the full bench. It says no jurisdiction.
They wish to take a preliminary point.
My lord, let them take.
You cannot stop them
No,
from taking.
my lord, what I am on, this preliminary.
We will hear them.
Submission.
We will hear you.
My lord.
Then I'll decide.
My lord.
Rightly or wrongly.
My lord.
Kindly,
Let them.
kindly, my lord.
My contention was, my lord, if my lord sees in none of the order, they have raised this point at the inception itself.
It will be there in the opposition. It's there in every opposition. Kindly, my lord, have the judgment, my lord, paragraph 34 and 35, which is on the last page of this thing.
Thank you.
Kindly see, my lord, this is a decision of the full bench, my lord. 34 says, para 35 itself is sufficient, my lord. Thus, High Court will have no jurisdiction to adjudicate upon the merits of case directing absorption or reinstatement in service of such employees with respect to the affairs of controversies as contemplated under the purview of the Act of 1985. Cases have to be filed before the Central Administrative Tribunal or Industrial Tribunal or Labour Court at the option of the employees. This is under a reference, my lords, has been answered like this. And this is a case admittedly of Electricity Department. There is no dispute that, my lord, they cannot approach the CAT or they cannot go to the Labour Court if they so wish. Now, therefore, my lord, this writ petition is not maintainable, my lord. If reinstatement relief has been sought, my lord, by means of a
They have challenged an order whereby you have refused reinstatement.
yes, so yes.
They can challenge this before the CAT.
CAT or Labour Court also they can.
Labour Court also.
And the point has been taken in the opposition, my lord. We'll see page 3 of the opposition. We have said that the writ is not maintainable in view of efficacious alternative remedy before Labour Court. Here we have said it is already exhausted, but my lord, that other point is also taken. My lord, they can go to the Labour Court, my lords, if they so wish, or they can go to the Central Administrative Tribunal.
Yes, Mr. Binnu Kumar.
My lord, may kindly come to this statutory settlement, page 51. This is a settlement under
51 of AO.
Of my writ petition, my lord.
Yes.
Now, my lord will find that this is 26th of October 2017. Minutes of the conciliation meeting held on 26th of October 2017 between Secretary Bijli Kamgar and Executive Engineer so and so. Now, my lord, kindly see the matter is in dispute has been discussed in detail and the union and the employer with the union and the employer. During the course of discussion, the union states that the DRM's mandates engaged through Pradhan have been paid less payment from 2008 to 2012 as per the minimum wages. Further, 74 DRMs mandates workers who were completed 240 days were retrenched without following the provision provided in the ID Act and hence became illegal. The union further demand to settle the less payment and reinstate the retrenchment DRM mandate workers immediately. The executive engineer stated that less payment case of worker will be verified from their records subject to submission of statement by the union. Regarding reinstatement of 72 DRM mandate worker will be verified from our record and those who are completed will be reinstated. Now, my lord, I am harping upon this will be reinstated. My lord, the judgment which my learned friend has cited, it says, my lord, to adjudicate upon the merits. We are not here, I am not seeking anything on merits. There is a decision arrived by the parties whereby they decided that we will reinstate. Now, my lord, kindly see, in view of the above, the conciliation officer is of the opinion less payment, if any, shall be verified and settled immediately, and retired DRM workers who were completed 240 shall be reinstated immediately for amicable settlement of the dispute. This is a statutory settlement under section 12 of the Industrial Dispute Act. It is binding upon the parties under section 18 of the Industrial Dispute Act. Now, my lord, when they have not
Mr. Binkumar, the very fact that they are not acting in terms of the settlement is a dispute.
No, it is not a dispute, my lord. My lord, thereafter I approach this court for execution of that, my lord, since it's a statutory settlement, if they are not acting, the authorities are not acting, I can approach the writ court. There are authorities on that. I approach this court. Now, my lord, may kindly see the order of this court.
Was this issue raised before that court?
Yes, my learned friend was opposing me, but there is no reflection. My learned friend has opposed. Page 56.
That issue of maintainability was not raised before that.
No, that raised, my lord. Their affidavit is there. I can place that. They have raised.
Not argued, but
Not argued. Not argued. My lord, may kindly see page 56, my lord. My lord, this is the second round of litigation. My lord, may kindly see this.
What stops you from going before the CAT?
My lord, already when there is a settlement, my lord, if there is a settlement, there is no disputed question of facts, my lord.
Problem is there is also Chandra Kumar, El Chandra Kumar. That is the
But
problem.
my lord,
You
so
see,
settlement
you
is
must understand, you have to look at our side also. Today, in spite of El Chandra Kumar, if a case is covered by the Administrative Tribunals Act, and in spite of that, if we entertain a writ petition, we get strictures from the higher authorities. Nobody is there to defend us.
my lord.
Therefore, we are very cautious.
No, my lord, that's right, my lord. But my lord, kindly see, my lord. My lord, I will try to satisfy this court that the question of maintainability has to be raised at the threshold. I have some authorities on that.
Maintainability of a particular list, that was a different list. This is a different list.
No, this list also at the time that it was filed, this is 2022, I have filed this writ petition. My lord may see any order whereby they have challenged the maintainability. In their opposition, they have said we are challenging the maintainability.
It is not a question of their challenging the maintainability. It's a bar on your client put by El Chandra Kumar and a bar on the court to entertain. That's the problem.
No, my lord may kindly have a look to this judgment, my lord. The coordinate bench has passed an order earlier.
Is the operative portion.
No, my lord may kindly see page 57.
57, what?
My lord, the settlement was reproduced there.
Yes.
The grievances of the petitioner was settled being aggrieved by so and so. The petition approached the tribunal. By such order, the petition was permitted to file a comprehensive representation. Thereafter, that was rejected. Thereafter, my lord, if my lord come to page 58.
Why did you approach the tribunal?
My lord, I was not the counsel.
Doesn't matter.
Yes.
But there, you see, that was the right thing to do, approach the tribunal. No, Mr. Bindu, you go. Go, I'll grant you leave to withdraw if you like. Go before the CAT. You don't, it's not that you don't have a forum. You have a forum.
My lord, the other issue is, my lord, these representation consideration orders do not confer jurisdiction to challenge that order before the High Court.
Anyway, I'm not going into anything.
My lord.
Hey, come, Stephen.
My lord may record, my lord, that
What? I'll record it very briefly the history of this litigation. Then.
and my lord, this because that order was passed on 2nd June 2022. So
Order
that,
pursuant to the High Court's order.
yes.
2nd June 2022. We'll say if the CAT is approached, we'll indicate a time frame sort of for early disposal.
No, my lord, one more thing, my lord. This 2022, my lord, as per the Tribunals Act,
yes.
If you are aggrieved by an order, the time limit under section 21 is 1 year. So, my lord, this period which that, my lord.
Section 14 principle, Section 14 Limitation Act.
My lord, since I was before this court, my lord may.
That's what I'm saying, section 14 of the Limitation Act,
Yes.
you'll be entitled to the benefit.
No, that is there, my lord. But if it is written, my lord, otherwise then I have to satisfy them on this for the delay also.
We will say that the tribunal will consider in condoning the delay, they'll consider the pendency of this.
My lord, earlier in one matter, my lord, where I approached this court in division bench judgment, the court said since he was here, if he approached within this period, the point of delay may not be taken.
Very well, we'll do that also.
Yes, yes, ma'am.
You are one or many?
No, my lord, this is an
Oh,
union, my lord.
Union.
Yes.
Settlement, where is the settlement you?
Settlement page 51, my lord.
51. A settlement was arrived at between the petitioner union and the management in respect of certain grievances that the petitioners had relating to their service. Stop. This was under the Industrial Disputes Act, 1947. Stop. The settlement was dated October 26, 2017. Stop. Paragraph. Since the management, alleging that the management was not acting in terms of the settlement, the petitioner union approached this court earlier
Page 56.
by filing WPA 116 of 2020. Stop. By a judgment and order dated December 9, 2021, a learned judge of this court directed the authorities to consider the representation of the members of the petitioner union for reinstatement of the concerned 74 DRMs / mandates workers afresh. Stop. Paragraph. Pursuant to such order of this court, the authorities passed an order dated
Dated, my lord. Order dated 2nd June 2022, page 65.
Okay. By an order, judgment and order dated December 9. Did I indicate that? December 9. Pursuant to the aforesaid order of this court, the authorities, where is that order?
Page 65.
Don't say the authorities, say the assistant secretary, within bracket power, Andaman and Nicobar administration, passed an order bearing number 1485 dated June 2, 2022, rejecting the representation of the petitioner union. Stop. That order is under challenge in the present writ petition. Paragraph. Learned advocate for the respondents raises a preliminary objection as regards the maintainability of the writ petition in view of the relevant provisions of the Administrative Tribunals Act 1985,
Right.
read with the Constitution Bench judgment of the Honorable Supreme Court in the case of L. Chandra Kumar, reported at blank. Reported at blank, he'll give you. Paragraph. Mr. I'm not recording arguments on this.
1997, 3 SCC 261.
1997, 3 SCC 261. Paragraph, learned advocate for the writ petitioner, however, says that a writ petition would be maintainable to enforce a settlement arrived at between the workmen and the management under the Industrial Disputes Act, 1947, paragraph. Having considered the rival contentions of the parties, I am of the view that in view of sections 14, 15, which are the sections?
14.
14, in view of section 14 of the Administrative Tribunals Act 1985, read with the and the decision of the Honorable Supreme Court in the case of L. Chandra Kumar, Supra, this I should not entertain this writ petition and relegate the petitioner to the Central Administrative Tribunal or the Labour Court as the petitioner may be advised. Stop. The Honorable Supreme Court. That's all. That's where we have stopped. Paragraph. Accordingly, I dispose of this writ petition by granting liberty to the petitioner. Only the union is the petitioner.
Union along with president. Union is
Then petitioners.
petitioners.
Always all the places petitioners. To the petitioners to approach the Labour Court or the Central Administrative Tribunal with the grievance that they ventilated in the present writ petition. Stop. If the petitioners approach one of those fora within 4 weeks,
3 weeks.
do it within 3 weeks. 4 weeks is within 4 weeks from date, that fora should decide the petitioner's grievance on merits without entering into the question of time bar. Stop. It is also that time bar, as expeditiously as possible and preferably within what is the time period reasonable? 3 months.
4 months. New bench, my lord, we don't know.
3 to 4 months.
Reasonable for the
4
new
months.
bench.
6 months. 6 months from the date of
4
receipt
months
of
will do, my lord. Otherwise, also now the speed, my lord, within 4 months.
4 months. 4 months from the date of date of receipt of
4 महीना में तो ऐसे भी हम खत्म करा ही देंगे.
the application from the petitioners.
Obliged.
I dispose of, I have said. So again, you say WP is disposed of.
Lord, item number 44.
44. 4.
Because he is out of service, my lord. Here, violation of principle of natural justice.
Reply has not
100%.
been filed. Reply has not
No, pleadings are completed.
been completed.
Pleadings are completed.
Not served on us.
Not sir.
No problem, let it.
No, pleadings are completed.
No
Long.
difficulty.
My lord, here, this petitioner was appointed on the basis of a selection process, my lord, duly in terms of the recruitment rule. He was selected, offer of appointment was issued, subsequently appointment order was issued in the year 2011. Since then, he was working under the respondent authorities. My lord, during the said process, he was appointed at different place as junior engineer, my lord. My lord will find at page 46, a so-called notice was issued. If my lord comes to page 46.
Page 46.
46, my lord.
Yes.
Now, my lord, here, my lord, kindly have a note of this. This petitioner, during the period from 2011 to 2018, was posted at a particular station at Jilla Parishad, Port Blair. Whereas the firm so-and-so raised a bill amounting to rupees 4 lakh for drinking water for the period from 31st March 2017 to 30th November 2017 and requested entry were made in the measurement book, whereas the payment was upheld by the Jila Parishad, and the firm has moved and filed a writ petition, whatever, my lord. Thereafter, next para is important, my lord. It says, whereas it has come out as a fact that the practice of procuring water through the firm was in wait since the year 2009, my lord, till the arising of the dispute. The payment were also released during this period to the firm regularly for the supply of water under different head of account, probably due to the fact that no work order was there. And whereas it has been observed that it is the part of serious administrative lapse on the part of he is the petitioner junior engineer, wherein no financial rule has been followed to procure water from private tanker on payment basis without work order as a practice which continue from year 2009 or even earlier. Now, my lord,
This is before he was employed.
before he was employed, they were continuously doing this. Now, my lord, the disputed period is 31st March 2017 to 30th November 2017. My lord will get it. Second paragraph, my lord. This is the disputed period. This was till it was noticed by the chief. So now, therefore, you are directed to submit an explanation to the undersigned within 10 days from the date of receipt as to why disciplinary proceeding action should not be initiated against you.
Yes.
Now, my lord, after issuance of this notice, my lord, he has submitted a reply. If my lord sees at page 48, he submitted a reply. He said that, the second paragraph, he said that I was posted from such period to such period that the bills of different dates amounting to 4,08,000 raised by MM's water supply, the supply of drinking water to Jila Parishad and so for a period from so, and the bills were verified and entries were made in measurement book by me, and accordingly the same was passed and forwarded by the then assistant engineer and the executive engineer of Jila Parishad South Andaman. Sir, before 2009, it was practice in Jila Parishad to procure the water and necessary measurement book entries were being done, and the payment to the parties were released through different head of Jila Parishad.
Yes.
Sir, I have done my job by following the direction of superior in Jila Parishad.
Yes.
Now, my lord, he was not at fault at all, my lord. Thereafter, he was transferred, my lord. Subsequently, his transfer order was issued in 2022. My lord, may kindly see now the impugned order, page 57.
No DP was initiated.
No, nothing. My lord, kindly see page 57. This is the order, my lord.
8th October 21, 31st May 22.
It says in pursuance to the direction of the Honorable Lieutenant Governor in the issue of supplying of water supply by the MSS and consequent the approval, the service of so is terminated with immediate.
No DP.
Contractual, they cannot be DP.
No,
Contractual.
my lord,
Contractual work. There is no
stigma
question
has
of
been cast.
Contractual, you would not even.
No, there are no rules. I'll explain, madam.
My lord, it cast a stigma.
CCS rule doesn't have.
My lord, kindly see the so-cause notice. They say that why
Was
a
that-
disciplinary proceeding was not initiated against you. And now, my lord,
So cause is issued and dismissal.
Gokul says the DP under the
Yes.
CCA rules,
Yes.
CCS rules. Gokul notice mentions
That
that.
perhaps is a mistake because it cannot be, my lord.
My lord,
There is no.
Everything the administration cannot just wish away by saying it's a mistake, Mr.
My lord,
Chakraborty.
my lord, I
Place
was
the
working
document.
from 2011 on the basis of a selection process. It is not that
I will
some
place it.
officer has appointed me. A selection process, 40 persons were appointed along with me. And my lord, the one more thing is there.
Was it a year-to-year contract?
11 months. 11 months.
But a selection on the basis of, my lord, security was taken, admit card was written, examination was conducted, and my lord, they were given appointment. Security bond was taken from them. Now, my lord will find, even my lord, though these petitioners, they were working for years together, more than 10 years, they approached the court.
My personal view, Mr. Chakraborty, is even if they are contractual,
My lord.
they are not slaves. Now, you cast a stigma of financial irregularity and somebody has been working for 7 years.
My lord,
You ask for a show cause as to why DP will not be initiated.
my lord.
An answer is given. You say nothing for 8, 9 months. Suddenly you terminate. This conduct, I am personally unable to approve of. You tell me what you have to say.
And my lord,
My lord.
yes, my lord, on same score, my lord, the recent Supreme Court judgment is there where it says same contract employee, my lord. Stigma was cast. The court said nothing doing, you cannot do this. Yeah, no, कई बार और एक बार ले लो. Now, my lord, may kindly see this judgment, my lord. Each and every line has a meaning, my lord. Word. Here also, my lord, if my lord sees paragraph number 4, my lord, after a selection process on contract basis, he was appointed. Para 6 says without inquiry, you could not have. Amount to punitive term. Para 6 is there, my lord. 9 to 11, my lord, not necessary. This is factual aspect of that. 6, 7, 8, all are relevant.
Natural justice.
And my lord, same thing, 2013 judgment also says, however, if an allegation of misconduct constitute the foundation of the action taken, the ultimate decision taken by the competent authority can be nullified on the ground of violation of rules of natural justice.
Which is what the Supreme Court
Yes.
said in this case, Mr. Chakraborty, is that the appointee had to undergo participate in a selection process, or practical purposes, he was like a regular employee and therefore entitled to natural justice.
The present case is very different from that case for the reason that my lord will see para 9 of the Supreme Court's judgment that these employees, though technically appointed on contract, get all benefits and allowances as per rules applicable. They are placed in a regular pay scale and extended annual increments, leaves, EPF, GPF deductions, contribution and other benefits. But for permanency in tenure, their terms and conditions are identical to those of a regularly appointed candidate. Now kindly see his appointment letter. He is not appointed against a pay scale, or he doesn't get the benefits and which a regular employee gets. He is purely 11-month contract with.
Okay, you show me authority that a person like this, like the petitioner, is not entitled to the benefits of natural justice or to have a disciplinary proceeding initiated or conducted against him before his contract not being renewed, and obviously on the basis of allegations of financial irregularity.
He has been granted a show cause notice. After that, it's been considered, and the reasons my lord finds to be insufficient, then that process can be carried out.
Nothing is there. Where is the reason? Simple termination.
Kindly see, my lord, the affidavit in opposition.
Yes. Just
Although it
give-
cannot be supplemented, but kindly see page 19.
No, what is that case? Mohinder Singhil.
Yes.
Mohinder Singhal, my lord,
Mohinder
Mohinder
Singhal.
Singhal.
1 second, Mr. Chakraborty. Let me just sign these orders. You do this, Mr. Chakraborty. Please come back on Monday.
My lord.
Now that I know what the case is about, it won't take time,
My
much
lord.
time.
Certainly.
You also do some justice to yourselves, both of you. Today is Friday.
My lord, my lord. My lord,
And your junior.
Yes.
my
This
lord,
is your
let it
pen.
come.
Your pen.
My lord, let it come as parthead, my lord, so that it can be upgraded, otherwise.
So I'll upgrade it. No question of partner, I'll upgrade.
Yes.
This will be the, let this be the first item, first hearing item. Heard learned, record and order, heard learned counsel for the parties, talk. Paragraph, list this matter once again on, give the date, Monday, as the first hearing matter.
My lord.
Obliged.
You also get time to find out case law if you want to.
The name is also biblical, petitioners.
Thank you very much. Wish you all a very happy week.